Welcome to another edition of Law Talk. I'm Clay Williams. I'm a partner at FH&P Lawyers, and with me today is my partner, Nancy Ling. Welcome, Nancy.
Thank you.
Nancy is, what do you do here anyway?
I'm also a partner here. I do a lot of transactional work, so real estate, corporate and commercial, buying businesses, and wills and estates.
And so I understand you've actually been doing a presentation to, I guess, to the public and know, realtors and that. And you've called it this really witty and interesting presentation called "Dealing with POAs and Estates." You couldn't have come up with something a little funnier, wittier?
I don't know. Maybe I could have made it rhyme somehow. I'm just not that clever, I guess.
So our topic today is dealing with POAs and estates. Riveting.
Yeah.
Okay, well, let's talk about POAs.
So that's power of attorney. Mm-hmm. Basically, it's when you want to prepare in case something happens, you lose your mental capacity, and you appoint an agent that can help you with your financial affairs. So it's a power of attorney, and that's the name of the document, but the attorney is also the name of the agent that you get to help you with your financial affairs. So it's planning for incapacity. And one of the things that your agent can help you with is selling real estate if you need to downsize. You're getting older, maybe you want to move into a seniors community or assisted living. You don't want to deal with the realtors, the bank, all that stuff. You can use your power of attorney or your agent to help you sell real estate. So there's a couple of steps and things about power of attorneys that people need to know if they're going to volunteer for the role. They want to help out their elderly parents or aunts and uncles or neighbors, and also stuff you need to know if you're going to use it for land title transactions.
Well, yeah, and I guess when I hear about it, it's usually a daughter or son helping their parents out and transitioning into, like you say, like an assisted living facility or something like that. But I guess it could be anybody.
Yeah. I mean, some people didn't have children and maybe they've got a really close relationship with a niece or nephew, or maybe even a neighbor. You can appoint anybody who's over the age of 19 and has all their wits about them to be your power of attorney. And it should really just be someone that you trust, because you are giving them all sorts of power and control over all your financial affairs. They can handle your banking, your taxes, your investments. They could sell your real estate. So you want to pick someone that you trust.
And sometimes you want them to sell your real estate.
Yeah, exactly.
So, now, when I think of a power of attorney, I think of it as something that might be operative when somebody's lost capacity.
Yeah.
Before they die, but has lost capacity. But that's not necessarily the case.
It doesn't have to be. So we all should have it put in place, because you never know what could happen. You could get into a serious car accident and have a traumatic brain injury. You could be in your 20s and that could happen. But a lot of people that traditionally think about it, they're planning for old age, and maybe they end up with dementia or Alzheimer's or something like that. But you can set it up. I've got one right now, and if I decide to hop on a yacht and travel around the world and I don't want to deal with filing my tax return, I could have my power of attorney do that for me. Or watch my investments, or I've got a house sale coming up and for some reason work takes me out of the country and it's not going to be easy to deal with all that. I can ask my power of attorney to deal with all the paperwork for me. So you don't have to be.
Can you? Is there, on a house sale, I mean, you're just dealing with, I guess, a purchaser and the land title registry, but and you don't need any special requirements to act as an attorney for somebody in those situations?
Yeah, so you'll have to jump through some hoops. So what you'll start with, if you're going to be selling a house, you have to hire a realtor first. The realtor is going to want you to sign a listing agreement, and they're going to want proof that you have the authority to sell this house that you don't own. So they're going to want to see the power of attorney. You're going to need to track down the original document, because usually what you're looking at or what's stored at your parents' or friend's house is a photocopy. So you'll want to know where the original is. It's probably kept at the lawyer's or the notary's office, and they'll be able to make you a certified copy to prove that the original is somewhere safe and you have a true copy of it. Then the realtor will know that they can take instructions from you. You can set the listing price. You have all that authority. And then the next person you're probably going to deal with once you've got a agreed upon binding contract to purchase and sale is going to be the lawyer or notary that's going to help you do up the legal transfer documents. So that lawyer or notary is going to ask again for the original, because if you're signing a transfer of a deed of land, the land title office needs a copy of the power of attorney. So your lawyer can register it. We do it all electronically these days, which is nice and easy. You're not mailing it to Kamloops. But the lawyer is going to need the original in their possession when they submit an electronic copy online to the land title office. And then once that's registered with the land title office, you as the power of attorney can sign anything that the owner could sign.
Are there any differences in acting as an attorney for somebody with capacity as opposed to somebody who's lost capacity?
Not really. You're still an agent and you have these responsibilities to account for the money. You're handling somebody's money or assets that aren't yours. So you are a fiduciary. You have to keep records. If you're acting for someone with capacity and they ask to see the financial records, you have to be able to produce them. If you're acting for someone without capacity and somebody gets concerned that you're not handling the money well, maybe they think you're stealing or you're pocketing it.
Yeah, who's this somebody?
Fudging the numbers. It can be any interested party. That's the thing with elder abuse and financial abuse. We do rely on people to report it when they see it. Quite often it's the bank. The bank sees, this client has had the same budget for the last 30 years and all of a sudden they're taking out $1,000 a day. Something is wrong here. So the bank might flag it. A neighbor or a tenant, if you've got someone who's got a basement tenant and they see, the power of attorney showing up with increasingly expensive cars, jewelry, anybody who's concerned about financial abuse can report it to the British Columbia Public Guardian and Trustee. So that's the government agency that's responsible for taking care of adults who are under a mental incapacity.
I see. Okay, well, so it's a little risky, it sounds like,
Yeah.
If you are acting for a parent and you don't get along with your sibling, there might be something going on.
Yeah, so, it is important to choose someone you trust, and it is important to have safeguards in place. If you use a lawyer to help you set this up, we put into place additional safeguards, like requiring your written consent to release it to anybody other than you, or requiring a doctor's note if we're going to release it when you're incapacitated. We don't just release it because the power of attorney asks for it. You do have these, hopefully, community members, family members, neighbors, banks, advisors that are going to report something if they see something suspicious. But at the end of the day, it is a criminal code offense to use a power of attorney to steal from the person who gave it to you.
And maybe you can explain to our listeners, like I do, like how we act as the gatekeepers for the power of attorney. We set it up as a trust obligation on our part. We're not going to release it out into the wild. Because you could do a power of attorney, say, there you go, off you go. But
store it somewhere safe.
Store it somewhere don't leave it on the coffee table, because that would be operative right away. So we actually keep it until
it's intended to be used. So we get our clients to sign it, the donor or the person giving the power, we get them to sign it ahead of time just in case it ever needs to be used. In a lot of cases, it sits in our vault until the person is dead because they manage their finances. They're sharp as a tack till their dying day. But it's there as that insurance policy. You want to have it in case you need it, right? So you sign it ahead of time. And generally speaking, we don't even get the appointed power of attorney to sign it until they actually need to use it. One of the reasons for that is when they sign it, it gets dated and we know exactly when they started managing the finances. So if money did start going missing last month, but the power of attorney didn't activate it until this month, we know something else happened last month that wasn't the power of attorney that took that money, or at least not using the power of attorney. And then the other reason we don't get them to sign it until we want them to use it is if photocopies are floating around and it does land with a realtor or a banker and they see, oh, I have a copy of it, but it's not fully signed. So they're going to start asking questions before they take instructions from that person. And also the person who's acting as the power of attorney, they have a responsibility to familiarize themselves with the person's budget so they don't overspend and overextend. So we don't want them to have to dig around and familiarize themselves with the person's budget until they actually need to get involved.
Okay, so power of attorney while a person's alive. You have a person called an attorney acting in their stead and do just about anything, or anything, I guess.
Pretty much anything. Yeah. So the agent can do anything related to financial, legal matters, but they can't do what we call testamentary acts. So they can't change that person's will. They also wouldn't be able to change the beneficiary on a life insurance policy because that's changing the estate plan. That's changing who their beneficiaries are. Same thing with the tax-free savings account. You can't just change the beneficiary to yourself or to somebody different because that's changing what the person wanted to happen after they died.
Okay. Well, that's good to know. And then they die. And then what happens after that?
So when they die, the power of attorney is kaput, expired, and then all of a sudden you have an estate and you'd be asking yourself, is there a will? Because then you're not dealing with the power of attorney anymore. You'd be dealing with an executor. So it's important to know if you are using a power of attorney for someone, the second they die, your authority under that document is over.
Yeah, and I'm of the age right now where, a lot of my friends their parents are passing away and they are named as the executor in a will, and there's usually a piece of property. And so how does that work? Now, I'm the executor. How do I deal with my parents' house or, piece of property?
So hopefully you're going to consult with a lawyer because we're going to want to order a copy of the title search and see, was anybody else on title with your parent? If it was both your parents, husband and wife, they probably owned the title jointly. And if only one of them has died, then it's pretty simple just to take the deceased person off title. We file a transmission to the surviving owner.
If it's jointly owned.
If it's joint, yeah. If the last parent standing or if there's only one person on title, then unfortunately we're going to need to get the will probated. And that basically is an old-fashioned way of saying it's proved valid by the court. The land title office doesn't want people, forging wills and transferring houses into their names willy-nilly. So there's some hoops you got to jump through with the probate court registry to make sure that the will is actually valid. It's the most recent will. Nobody who's a beneficiary or a family member can make any claim that it's a forgery or the person that made the will did not understand it when they were signing it. So there's a couple of hoops to jump through to make sure it's valid. Once that's all done, you get a grant of probate. You give that to the land title office. And then similar to with the power of attorney, once that's registered with the land title office, the executor can sign all of the documents that the deceased person could have.
Does the title actually pass to the executor?
Yeah. So once you file that grant of probate, the title will now show. So if it was me, Nancy Ling, executor of the will of Jane Doe. So a realtor or buyer, anyone looking at title would know that me as executor, I have the ability to sign the sale documents on behalf of the estate. It's not my property. I'm holding it as a trustee for the estate and for the heirs and beneficiaries of that estate.
Now, one of the questions I get all the time is whether a child should be put on as a joint owner of the family home to avoid probate fees. And, I think our listeners would be perhaps surprised at how little the probate fees are here. What are they?
It's not a straight percentage, but it works out to approximately 1.4%, which all things considered is a lot cheaper than the capital gains tax rate, some of the other fees and taxes and filing fees that you can incur if you do that, putting a child on title. It used to be, it's sort of bad advice that's floated around often as the golden solution to avoiding probate. But there's a lot of reasons why you don't want to put a child on title. So when I say child, I mean an adult child. You can't put a minor on land title. But you're getting up there, maybe you're in your 80s, you want to put your 60-year-old son on title with you. If you live in the house and your son doesn't, you're the only one that qualifies for that principal residence exemption from the capital gains tax when you eventually sell it. So if you put your son on title for 50%, you've got to explain he doesn't really own 50%. He's just on there for convenience. Federal government and Canada Revenue have decided they don't like that. That's a trust. and trusts have to disclose information now and do tax filings for a trust return.
Yeah.
That's also one of the things that will trigger the requirement to file that new underused housing tax return. So you're filing a trust return, you're filing an underused housing tax return. You're having to deal with the speculation tax exemptions now, and all these headaches. Plus, if that son goes through a divorce, I'm sure the spouse is going to make a claim for that house. If that son gets into a lawsuit or bankruptcy, those people are going to make a claim for the house. You might be able to argue against it, but you're still going to get dragged through the mud with that son.
So the takeaway from this is it's not always the best idea to, go on with your parents jointly as opposed to just allowing it to go through probate, which sometimes is cheaper.
1.4%. Plus,
1.4%,
the risk of needing that son's signature anytime you need to refinance, sell, or do anything with the property, you lose control there too. So it's not a clean, simple, golden solution that some people think it is.
Come see Nancy.
Yeah.
Nancy will tell you what's what.
You bet.
All right, anything else you wanted to talk about?
Obviously, there's lots of complexities that come up with it. Every situation is different. The best advice is just, if you're in one of these scenarios, call a lawyer, call us before you make the wrong step.
And if you call me, I'll tell you to call Nancy. So, all right, till next time.